all 7 judges believe that Kwesi was not eligible. The dissenting part, we will get there. It has to do with whether or not the court should apply its discretion to entertain an application of injunction in these circumstances. Justice Kulendi felt that, yes, because of community with the Constitution, we should. Other judges felt no. Let's go straight and look at it. Okay, so we select aspects of it and we show you what we think is most relevant. So he says, from the litany of judicial decisions, it has long been settled that in considering an application for injunction, a court ought to consider entirely the following. Now, Justice, we have picked this part to start with because that's where the argument really turns between the majority opinion and the minority opinion, whether or not the court should have entertained an application of injunction. So what is the application of injunction about? It's important that we clarify this. After the High Court had given the ruling and the appellant, which is Kwesi and his lawyers, had failed to comply with the regulations of the Court of Appeal and therefore were thrown out of the Court of Appeal, and so the application for appeal was not heard because they didn't comply, Mr. Kwesi was still continued to attend Parliament. In fact, indeed, on the 6th of January, when Alexander Fenyo-Markin, the Deputy Majority Leader, raised an issue reminding the clerk that you have been served with an injunction on one of our members, so he ought not to be here. That's what brought the whole fury of the 6th of January event. And I was there, we saw it. It was quite interesting. Ahead of the election of the Speaker, Right Honorable Aban Bagbin. So the point that Frank Davis went to court in this Supreme Court matter, inviting and invoking the Supreme Court's jurisdiction for an injunction against Kwesi, was because Kwesi was failing to comply with the High Court's ruling, which said he was ineligible and cannot hold himself as a member of Parliament, and the Court of Appeal decision to throw out the appeal on technical grounds, and therefore there's no appeal pending. That with these two rulings, Mr. Kwesi should have, as Adamu-Sakande did, to leave the Parliament, but he was not leaving. And as Frank Davis told the court, the majority, the group he finds himself in, the minority and DC, were also encouraging him to remain. The Speaker seems incapable of telling him that, Mr. Kwesi, you lost 2 court cases in the High Court and Court of Appeal. Your eligibility is being challenged. It's actually been pronounced upon by the High Court. Please leave and comply. And they didn't do that. No one did that. So Frank Davis found the need to go to the Supreme Court, the apex court, and tell the court that somebody is violating the Constitution of the Republic, the Constitution that the Supreme Court has been set up to protect. That's the matter that went before the court. That is the first level, is whether or not the court will accept the injunction or not. Because should the court accept the injunction and treat it, 2 judges felt that no, the High Court has given a ruling, every Ghanaian should comply. If Mr. Kwesi doesn't want to be complied, he should be made to comply. You don't need the Supreme Court. That's Amegache's opinion. Justice Kulendi felt differently. Let's listen to him. Let's see why he thinks differently. He says, from the litany of judicial decisions, it has been long settled that in considering an application for injunction, a court ought to consider entirely the following facts. He says, whether, these are the facts he's considering, whether they should accept the injunction motion or not. Whether the case of the applicant is not frivolous, that is to say, whether the applicant's prima facie has demonstrated a legal or equitable right that ought to be protected by the court. Whether hardship will be occasioned if the application is granted or refused, and which of the parties will suffer greater hardship. And C, whether on the facts it is just and convenient for the preservation of the status quo. Okay, and D, whether the loss, damage, or injury can be quantified in money, and whether damages could afford adequate compensation if the application was refused. So he walks us through the basis on which the court will determine whether they should hear an injunction application or not. In this case, an injunction against Kwesi, that he should get out of Parliament. Okay. He goes on, this analysis, as he calls it. We are clear in our minds that this application is founded on a writ invoking our original jurisdiction and does not arise directly from the prior actions in the High Court. Consequently, neither our original jurisdiction nor this application are grounded on the judgment of the High Court. However, in the exercise of our discretion, the antecedents in the High Court are relevant facts that will inform our evaluation of the equity, justness, and convenience of a grant or otherwise of an order of interlocutory injunction. The matters complained of by the applicant per his unchallenged depositions in his affidavit in support and, moreover, borne out of the various annexures to his said affidavit are of grave concern. They are allegations of willful continuing breach of the Constitution and allegations of contemptuous defiance of the authority of the High Court, a superior court of judicature. Breaches of the Constitution do not affect an individual applicant alone, but the entire Ghanaian populace, which have adopted for itself the Constitution as their supreme law. Needless to say, the Constitution is the safeguard of our democracy, without which the institutions of state will not exist. It is the source of authority of the entire governance structure of the nation. It embodies the aspirations, goals, expectations, dreams, and ambitions of the over 30 million Ghanaians. It is the source book that enjoins our collective efforts to usher ourselves into prosperity. Therefore, it is the mirror by which every individual must do a reflection to ensure that our actions do not go contrary to or in violation or defiance of the collective will of Ghanaians expressed in the Constitution. Per the uncontroverted depositions in the affidavit of the applicant before us, it is undisputed that the first respondent, being Honorable Kweson's election as a member of parliament for the Assin North constituency, has been declared by the High Court to be null, void, and of no legal effect whatsoever. Now, this is interesting, isn't it? And those who say that the judgment is political, you heard it, you read it. Justice Kulendi is saying that what has been brought before the court, the depositions made before the court, unchallenged, is that a high court has ruled that somebody's election is null and void. A high court has ruled, and the applicant with affidavit is saying that this man, against whom a high court's rule has been given, is continuing in the breach of the Constitution by continuously attending Parliament every day in the face of a clear High Court ruling that he is not eligible to. But why will anyone do that? In 2022, why will anyone do that? A democracy that's run for 30 years, why will anyone do that? And why will any group of people support somebody who is doing that? The man has been told by a High Court that you're out. You couldn't file your appeal. The process ends at the Court of Appeal in the parliamentary election challenge. It doesn't go beyond that. Databan has said that in their law reports. We know that already. It doesn't go beyond that, okay? So you know that you are not eligible. You continuously attend it, and people among his group are supporting him. When you say that this is lawlessness, they say that you are saying something. This is absolute total lawlessness. And if the Supreme Court didn't come in to deliver it in this way, is that how we're going to deal? You lose election. A court has ruled that you've lost the election. We have agreed under the Constitution that we go to a court for an election dispute. Court rules that you've lost the election. And then you say that I continue to be in Parliament. I don't care. And people support him and say that, yeah, you can't do that. You really cannot do that. And you shouldn't do that. That's not how to build a democracy which is 30 years old. Okay, let's move on. He says the Cape Coast High Court have said null, void, and of no effect. It is again unchallenged that there was initially an order of interlocutory injunction dated 6 January 2021 restraining the first respondent from holding himself out as a member of parliament elect for the Assin North constituency and presenting himself to be sworn in as a member of parliament until the final determination of a substantive petition filed against him. Further, it is undisputed that the High Court in its judgment dated 28 July 2021, among others, granted an order of perpetual injunction against the first respondent, being Mr. Kweson, on the same terms as the preceding order of interlocutory injunction. These orders, notwithstanding, the applicant laments at paragraph 9 of his affidavits in support, which is set out supra, that the first respondent, being Honorable Kweson, is contemptuously holding himself out as a member of parliament and carrying out parliamentary duties because on the 6th of January 2021, when members of parliament were to be sworn in, the first respondent, being Kweson, attended the chamber of parliament, offered himself to be sworn in as member of parliament for Assin North constituency, and has since continued to hold himself out as a member of parliament for the Assin North constituency. We are not unmindful of the fact that if we grant the instant application and the first respondent, being Kweson, in the end be adjudged by this court as duly qualified to have filed a nomination and for that matter elected member of parliament, he would have suffered damage, loss and injury on account of an interlocutory restraint. Similarly, his constituents as well as the party on whose ticket he is in parliament would have been affected. Okay, let's move on. Consequently, the absence of the first respondent, Honorable Kweson, even if temporarily, will occasion some inconvenience. On the other hand, the applicant at paragraph 12 of his affidavit in support points to the constitutional nature of his suit and laments of untold distress and loss for himself and the other constituents of Assin North who ought not to have been saddled with an unqualified person to contest the parliamentary election of that constituency. In the first place, and that this distress and loss are irreparable and can in no way be remedied by the award of damage. So Justice Kulendi is painting both parts. If we give it in his favor, this is the loss occasion. If we give it against him, this is the loss occasion. Let's see which side he goes to. He says, the substantive suit Being a public interest action, the persons whose interests are at stake are not only the applicant, the interested party, or the constituents of Assin North, but every Ghanaian, because every citizen has a community of interest in this constitution, a violation of which the applicant has alleged in his writ of summons. The constitution itself, in Article 3.4, places on all citizens the duty to at all times defend the constitution, and in particular to resist any person or group of persons seeking to overthrow the constitution. The exclusive reservation of this jurisdiction to the Supreme Court is a constitutional indication of the sanctity with which the framers of the constitution intended that it be treated. Consequently, an allegation of a breach, and more so a subsistent and continuing breach of the constitution, constitutes an invasion of the sovereign will of the Ghanaian people. Occasions an incalculable damage, injury, and convenience which warrants serious and urgent judicial attention and intervention. No court, Justice Kulendi says, organ or agency of this republic can or should be insensitive, aloof, indifferent, and or unconcerned about an allegation of a violation of this sacred and basic law, let alone a subsisting or continuing violation. Otherwise, it will be condoning a subversion of the constitution and sovereign will of the Ghanaian people in an irreparable way. In this regard, the balance of convenience tilts in favor of the Ghanaian people, whose community of interest in the constitution is sought to be vindicated if the applicant's compliance is eventually upheld by this court. Similarly, we are of the opinion that the applicant and the constituents of Assin North would have had an unqualified member of parliament should the applicant succeed in the end. In the circumstances, greater hardship, irreparable damage, and inconvenience will be occasioned the constitution, the rule of law, the tenets of democracy, the constituents of Assin North, and the Ghanaian people as a whole, if the first respondent, that is Mr. Kwesi, be allowed to continue to hold himself out as a member of parliament for Assin North, pending the determination of the suit. Having regard to the subsistent judgment of the High Court suit number so, which was attached to this application as Exhibit MAN2, the status quo is as determined in the judgment. That is to say that in the eyes of the law and elections, the election of the first respondent, Mr. Kwesi, has been adjudged to be null, void, and of no legal effect whatsoever. Until the said judgment is vacated, overturned, or set aside by a court of competent jurisdiction or suspended by appropriate legal steps, the first respondent, Mr. Kwesi, cannot be said to be lawfully performing the duties of an honorable member of parliament. The auspicious office of a member of parliament is one which is created by law, and therefore no person can occupy it in disregard of the law. It is our further considered view that the court will be failing in its exclusive mandate and duty to Ghanaian people to uphold and protect the constitution if it does not suspend, mitigate, or abate an alleged constitutional illegality, as in this case, or an established, proven, and adjudged constitutional illegality if the applicant were to succeed in the end in the suit. Such a failure, neglect, or omission will endanger the sanctity of the constitution, our democracy, and for that matter, the safety of the republic. As the highest court of the land, it will be an indictment of the administration of justice in this court if this court did not uphold the subsistent judgment pending a final decision on the constitutionality question raised before us. Though we are not exercising an appellate, supervisory, or some other jurisdiction in respect of the judgment of the High Court, we must note that through Exhibit so, the first respondent, Mr. Kwesi, has been perpetually restrained from holding himself out as a member of parliament for the Assin North constituency. Further, the unchallenged allegation by counsel for the applicant from the bar that the first respondent, Mr. Kwesi's appeal to the Court of Appeal Cape Coast has been struck out. The dignity of the rule of law is non-negotiable. There can be no justification for ignoring the submissions of the continuing disregard of the orders of the High Court which have not been suspended or overturned. This makes the grant of this application more compelling. For these reasons, we have no hesitation in concluding that an order of interlocutory injunction restraining Mr. Kwesi from holding himself out as a member of parliament for Assin North constituency, presenting himself and or attending before parliament to conduct the business of Member of Parliament pending the final determination of the suit. However, in order to ensure that the case is expedited, the court directs that they cooperate with the court. The court directs that they cooperate with the court. To this end, the court, by way of case management, will issue directives and, if necessary, make orders as to the future conduct of this case. In this respect, the parties are to file their joint memorandum of issues, failing which they can file their separate memorandum of issues. Okay, so there is a matter. Okay, let's do the conclusion. We have considered in detail the processes filed in this application, as well as submissions made by both applicant and the respondent. We are of the considered view that the instant application has merit, and the same is hereby granted as prayed. The first respondent is hereby restrained from holding himself out as a member of Parliament for Assin North constituency, presenting himself and or attending before Parliament to conduct the business of a member of Parliament pending the final determination of the suit. Kulendi, Yoni, Emmanuel, Justice of the Supreme Court. Now, what's wrong with that? So Justice Kulendi says, simply, Justice Kulendi says, the matter was pronounced by the High Court. So there's a matter pending before the Supreme Court. It's a matter of constitutional interpretation. That do not actually even speak to the eligibility of Mr. Kwesi. Not quite. But it's pending before the courts. And that's like a side matter, like what lawyers always do. They file another issue. So there's some matter continuing in the court about Kwesi versus, or somebody versus Kwesi relating to Assin North. But the substantial matter about whether or not he's eligible has been determined by the High Court. And the Court of Appeal struck out the appeal for want of compliance, as it were. So Justice Kulendi is saying that how can a man continue to resist and violate the Constitution in this manner? The Supreme Court cannot sit down and just look at it. They cannot. They cannot sit down and just look at it. They will have to deal with it.